much appreciated. Our last speaker of today's discussion is Mr. Mridutpal Bhattacharya, Deputy Chief Innovation Officer of the Indian Society of Artificial Intelligence and Law and Director of the Indian Library on Artificial Intelligence and Law. Mridutpal, the floor is yours.
Thank you, ma'am. And first off, let me say this that the whole of ICL is very honored at me being able to present here. Thank you to Trends for the opportunity. Let me share this screen. Is it visible? So, with alignment to what Mr. David said, that theoretical laws are actually not really what parties to a cyber attack would look forward to in terms of the practical world. However, I will be placing an emphasis upon customary international law and not just statutes. Well, what do we actually mean when we use the term cyber operations? Now, the National Initiative for Cybersecurity Careers and Studies has actually referred to cyber operations as performance of activities which are of a counterintelligence nature. However, it is to be noted that that is not the only objective of cyber operations. Cyber operations can be malevolent as well as benevolent. Furthermore, Thomas Aquinas had actually defined law to be the common sense of the global citizen. However, that is not the case when it comes to international law, because we are incessantly reliant upon statutes. So, what Colonel Gary Brown of the United States Air Force and Kita Coelette, Major of the United States Air Force, had said was that the first thing to know about international law is that it bears only a slight resemblance, only a passing resemblance to the kind of law which most people are familiar with. Domestic laws in most countries are passed by some sort of sovereign body after due consideration. Statutes are carefully crafted so the law has a precise effect. International law is nothing like that. Contrary to popular belief, treaties are not the primary means of establishing international law. The body of international law is a jumble of historic practice and tradition, as well as signed agreements between nations. Within this patchwork of guidance, customary international law occupies a position of prominence in developing areas of law, ahead of treaties and conventions. Now, in the absence of specific legal regimes for cyberspace, the logical approach should be to take the existing guidance towards governance of conventional warfare and consequent determination of whether the same can be applied to cyberspace. Now, the commonality of states disagreeing, obviously, states all the time disagree upon practices all throughout the world, which are accepted as law in other places. As exhibited in numerous state actions, published government materials, official government statements, domestic laws, and precedents that derail actual practice. Over time, however, specific instances of state practice often develops into general custom. Like a very nice instance of the same would be the fact that certain states of the USA actually follow the Tallying Manual 2.2, while the same is regarded as a binding statute all through the world. The second part of the equation is tougher. For a custom to become binding, states not only need to act in a certain way, but need to act in the certain way because they think that they are legally obligated to do so. That is, the doctrine of opinio juris needs to be observed. Now, there are no mathematical formulae suggesting how many states should actually accept a practice or for how long for the practice needs to be established for it to become a binding custom. It would not be unwise to say that the more states follow a particular practice, the more likely the practice is to become a law. But however, what is the most important thing here is that the most powerful states in terms of that particular field take it upon themselves, take the initiative to make sure that the customary laws are established. Because the practice of politically powerful and active states carries more weight than of smaller nations, especially ones which are not actively engaged in the area under consideration. Now, a very good instance, and this is only an illustration, and by no means do I want to hurt any sentiments. It is well propounded that the practice by USA or the UK will have a heavier effect on the development of international naval operations rather than those of Switzerland or any other landlocked state. That is to say, that exactly that what I said was relevant powers in the relevant fields are the leaders in those fields in terms of starting and maintaining practices for them to develop into customary laws. Now, the length of time needed for a practice to become custom can greatly vary, as can be observed from the law of war. The customary law of war started developing millennia ago. For example, the Greeks had actually started developing the concept of jus ad bellum, just war, in the 4th century, while jus in bello, that was war during peacetime, only assumed their current forms in the 1860s during the Franco-Prussian War and the American Civil War as well. The documented atrocities in those wars actually led to the rapid developments of the modern law of war regime, starting with the first Hague Convention in 1899. Another example of customary law is that developed rather quickly is space law. In 1958, just after the year of the launch of Sputnik, which was in 1957, the UNGA, the General Assembly, created a committee to settle on the peaceful uses of outer space. By 1963, the UN had put forth the Declaration of Legal Principles governing the activities of state in the exploration of outer space, and this principle is followed till date. Now, what needs to be avoided at all costs is the inaction of states when on the receiving end of conduct harmful to it. Because I just stated the concept of opinio juris. So even inaction can become established practice. The official silence of the victim states can become evidence of the fact that the misconduct either did not occur or that it is not questionable in terms of international law and that does not violate any international laws. Such passiveness can cause a binding effect under the doctrine of acquiescence. I can cite a very recent example as well. Okay, let's wait for that. Let's go on with the other instances at first. So, arguably, the first cyber attack occurred in the Soviet Union in 1982, when a Trans-Siberian pipeline exploded. It was recorded by a US satellite and was referred to by one of US officials as the most monumental non-nuclear explosion and fire ever seen from space. Now, such a monumental explosion was denied by the Russian government. It is alleged that the Russian government, the KGB, the Russian Committee for State Security, was embarrassed by the fact that since it is alleged that they had actually stolen software that was developed by a Canadian company for usage in maintenance of pipelines, and the same was apprehended and predicted by the US Central Intelligence, and the US Central Intelligence had supposedly planted a bug which caused the pipeline to blow. Now, after that, there were numerous soft computer attacks against US systems such as the Moonlight Maze, Code Red, Mountain View. Then there was the Estonia crisis, where in 2008 Russian troops invaded the Republic of Georgia during a dispute over territories in Southeast Asia. In August, prior to the intrusion, all Georgian government websites were subjected to a denial of service attack and defacement. The actions have not been attributed to the Russians, despite there being a lot of speculations. The US received a wake-up call when a worm titled Agent.btz infiltrated the US military classified records through a flash drive by a foreign agent. The purpose was to transfer US defense intelligence to foreign service. The US Cyber Command was established less than 2 years later. There were Google's allegations against Chinese hackers in 2010. Then the Stuxnet was established. The Stuxnet was a worm which primarily targeted the supervisory control and data acquisition system manufactured by Siemens. Stuxnet determined the worm was designed to affect, like, the original determination was that the worm was designed to get into Iran's Bushehr nuclear power platform or its uranium enrichment facility. However, later on, there were indeed a few malfunctions in the nuclear department, but none of them were confirmed to be caused by the Stuxnet worm. The Iranian president later stated in a news conference that the malicious software indeed had damaged the centrifuge systems, although he did not specifically state that it was Stuxnet. With regards to and another example is recently in January itself, India in Mumbai there was a power plant that was attacked, allegedly attacked. Now what happened was a certain area of Mumbai suffered a blackout for about 4 hours, and after that what happened was a lot of media outlets covered the incident, um, and they were news. But later on, the IT ministry did not actually issued an official statement stating that there was no attack. However, now the funny thing that happened was my organization decided to research this issue. What we experienced was that the day when the attack happened, a few hours after that, many numerous media outlets on their websites had the incident put up. The next day, when we started to actually do a research on the same, all of those websites, when we started opening them, simply showed a 404 code error. Therefore, the all of these news bulletins were deleted. Now, this is the kind of inaction that actually becomes practice, and this is the inaction that absolutely has to stop. Now, the difference between espionage and assault. Now, what is an espionage? Espionage, as globally accepted, refers to the practice of using spies to gain intelligence, while attack refers to an actual assault or use of force. It is to be kept in mind that in case of an incidence of cyber attack or espionage, there is no international legal body that a state can go before and ask for the ordering of discovery or ask for collection of evidence or investigation. Neither the ICJ nor the other courts can fill this role. Any evidence collected would be classified as a secret and would probably contain politically sensitive information as well. Hence, no good would come out of letting the states investigate their own selves. Witnesses could mostly be politicians or intelligence officials, so unless a polygraph test can be administered, none of what they testify would be considered true. The issue of international intent has not been much the fabled mens rea has not been much discussed since it applies under the laws of war. Now, in case of laws of war, the intent is generally unambiguous. Thus, an interesting conundrum comes up, a very interesting conundrum indeed. Now, the conundrum is if intent indeed does not matter in cyber operations, and only a few keystrokes determine whether a cyber activity will constitute espionage or assault, then any intrusion for collection purposes is potentially a threat of use of power. But if that's the case, then why has not the Security Council been extensively proactive on the issue of cyber operations?
Sorry, Mr. Mridutpal. Just a couple of more minutes.
Thank you, ma'am. All right. So they need a lot of cyber. There are a few laws, not a lot of laws, but not many of them are binding. Let me go to the final slide. So, if the reports from 2013 and 2015 and the resolution of the General Assembly 2018 beyond reasonable doubt established the legal provisions and practices for and against cyber operations, why have significant changes not taken place? Why have older disputes not resurfaced in courts? Why are states maintaining practices against the state established laws? As stated earlier, inaction turns into practice, which in turn evolves into custom, and that is precisely what is holding states back from adhering to the norms laid down, apart from their own benefits outweighing the global good. And these are questions to be pondered about. The only way to do away with that is for the foremost leaders in technology and cyberspace to lead the way in complying with international standards that have been set. But what is to be done if one or more field-leading states are inclined towards non-compliance simply because they benefit from illegitimate cyber operations? Such a scenario places the onus upon the UN itself to interfere and motivate the state into compliance and make sure that the compliance ensues long enough to ensure that other following states have been persuaded into complying and that the compliance has turned into an established practice or a custom. There are two broad challenges, and they are: given cyberspace's unique characteristics, interpretation of international law that is applicable to cyber operations may require a certain level of adaptation and not transformation. The subjects of international law, particularly states, may have different, if not divergent, interpretations of certain specific provisions of international law. Now, many people argue that a consensus can be reached, as was reached in case of the UNCLOS, and that happened rather quickly. But what needs to be understood is that preceding the establishment of the UNCLOS, there was a lot of discussion and deliberation upon the same, a lot many years of deliberations, and that has not happened for cyber laws. That has not happened for cyberspace in the international context, at least. Now, other than that, transparency framework should be established as being as are being stored towards by the EU. Legal awareness campaigns should be done. CERT personnel and committees should be created and maintained, and every state should be encouraged to adopt cybersecurity strategies. The age-old norm of inaction or passivity needs to be done away with. It must give way to newer methods, whether offensive or defensive. And this is, I cannot lay more emphasis on this. This is the most important. Inaction must go away. Ideally, the best defense is a good offense. Proverb should be set aside and focus should be awarded to cybersecurity and resilience. Simply put, the focus should be on inhibition and recovery rather than identification and destruction. Thank you.